Welcome. I recognize at least Lisa Novak. Hi, Angie and Melanie and Mary and everybody. We're going to have a wonderful presentation this evening. I'm just going to quickly introduce Heather Valdez and Cristina Nolan to you, who will be making the presentation, and I'm going to kind of disappear. But you're in for a lot of good, valuable information that was really seriously going to help you. And they've been colleagues of mine for a million years and know this material so well. So enjoy the presentation, and I'm gonna let them take over.
Thanks, Site. Welcome, everyone. We're so glad you're here. I'm Heather Valdez, and tonight Professor Nolan and I are going to walk you through primary and some secondary sources of law, and then briefing a case.
Hello, everyone. I'm Cristina Nolan. Nice to meet all of you. I just see that we had a question in the chat about will they. Hi, Angie. Oh my gosh, Angie. I just saw a question in the chat about whether or not the PowerPoint will be available, and I believe it will be. I think we might be able to even send it out during the presentation if we're able to, or if somebody gets a chance to do that. But yes, it should be made available. It's so nice to see Angie. I switched tracks from B to A, so I miss a lot of my B. Well, I miss all of my B track students, but Angie, I have to say, is one of my favorites. So it's so nice to see you here, Angie, and everyone else. So Heather, you can advance the slide now, and we'll get started. So we are going to begin by talking about the different types of legal sources, and probably, those of you who are here now, I'm sure you're very familiar with these already. Even if you've only taken a class, you probably have some sort of idea of at least what they are. So let's look first at primary sources. So these are, what are they? They are books and online. Oh, yeah, you can turn back, Heather. Thank you. Yes. Okay. So we'll get into a little bit of the nitty gritty of each, but we'll just look at sort of generally what they are. Constitutions. This could be a state constitution. This could be the United States Constitution, the federal constitution. You could have statutes, individual statutes, regulations, like administrative regulations. I'm teaching administrative law right now, and that's all we're talking about and looking at, in cases. So these are all primary sources of law. As you know, the primary sources, I just feel like calling them the best sources of law, but they're just like the highest sources of law. And then we have, of course, secondary sources. Some examples of these are books and treatises, dictionaries, ALRs, legal encyclopedias, periodicals like law reviews or bar journal articles. Secondary sources are excellent for, when you want to get sort of a good overall picture of the topic or issue, and just really get like think about an encyclopedia. We don't really use them anymore, but like in the 70s and 80s, if you wanted to know anything about a topic, you would just, look it up and turn to the page and read all about it. And of course, if you wanted to cite an encyclopedia, in a grade school paper, they wouldn't like that because they'd want you to do like additional research. But the encyclopedia gives you like this big picture of the topic, and they're helpful in that way. And lawyers, paralegals like to use these types of secondary sources, especially when they don't have a really good understanding of the subject. If it's sort of a new type of case to them or a new issue or something they're not familiar with, it's always a good idea to do this. It's not exactly like a cliff note, but it could kind of be like a cliff note type of thing. Okay, and please advance the slide to the next slide. Thank you. So what are primary sources of law? These are, so again, the statutes, the regulations, the constitutions, case law. These are essentially the formal written statements of law issued by government entities. They could be found in physical books. They can be found in an online, obviously the reputable website, the actual website where the law comes from. It could be a work that contains the actual law, such as a statute or court case or an opinion, or the law itself. These are some good ways of describing primary sources. Next slide, please. So secondary sources are not the law. This isn't the actual law. Again, that's the primary sources. Secondary sources are anything other than the law. They explain, summarize, or analyze primary authorities. And really, they help us to locate primary authorities. We talk about Wikipedia sometimes. This is something not to cite in your paper. You don't want to cite directly to Wikipedia. There's many reasons for that, but Wikipedia, I kind of think of it as a secondary source. So sometimes is in that it gives you the general overall picture of things, and it also may help you find good authority. At the end, a lot of times the Wikipedia site will have some like really reputable, great articles, scholarly articles. So sometimes the secondary source can help you get to the primary source. One thing I wanted to mention here too, if you have not been to our Purdue library in a long time, you really should take a trip there. I have to admit, probably before the last year or so, I didn't really use it all that much. I didn't really realize how much we had there. In the past year, yes, Westlaw is awesome, Angie, but in terms of the secondary sources and journals, it's amazing. I mean, we have so many law journals in our library. You wouldn't believe it. So pretty much, I mean, there were very few that we couldn't find in the library. So always look there too. Thank you, Heather. It's, has anyone used Google Scholar? I've used that before, but it's not anywhere near as good as our actual library. Of course, our library, we have our librarians and other resources. So if you need to research something, they will actually help you do it too. So use the resources you have. That's sort of my little soapbox here, my little side soapbox. Use the resources that we have because they're really, really helpful. And if you don't know where to begin a search, which is a lot of the time, you get a paper, where do I begin? Starting with the secondary sources is always a good idea. They're going to explain the law. It's not mandatory. It's a persuasive explanation. You use this information to subsequently find primary binding authority. So, if you are writing something to a court, a motion, a brief, you're obviously going to want to use your primary authority. Sometimes, though, you can insert a secondary source to sort of help explain your primary source, but it's the primary source that's binding. Next slide, please. So federal law, state law, this is under the category of primary sources of law. So some examples in federal law are like the Constitution, federal administrative regulations, the United States Code, federal cases. These are all federal primary sources of law. So if you are making an argument and you want to quote a piece of the Constitution, you are quoting a primary source of the law that's going to really, you're really going to be making a strong argument if you're able to do that. Then in terms of state law, what are some primary sources? We have state constitution, state administrative regulation, state statutes, codes, laws, and then state cases, state case law. So at the very bottom of this slide, we have a nice little definition and it sort of explains what a primary source is. Again, the primary source is the actual law. So think about it. I mean, primary, this is primary, the first source, the main source. This is the law. Secondary is more like a tool that is used to help you understand the law. Again, a legal encyclopedia, law review, or legal dictionary. A law review article, sometimes they can be very long and in depth, and you don't really want all that information. In that case, you may want to go to the legal encyclopedia or a dictionary just to get sort of a snapshot of what it is that you're trying to understand. But if you're writing a paper and you really want to understand the issue more in depth, that's where you may want to go to a law review article and utilize that. again, to help you understand what the law is. But sometimes, you know, you want, you know, if you're looking at a law review article, there may be a certain argument that the writer is trying to make. So they're obviously using the information that they have to sort of make their point, make their argument. So it gives you a good perspective of like the different you know, issues there. Heather, can you please turn the next slide? And then I noticed Lisa has a good question as well about the dissent. So how is the United States Constitution structured? We have the preamble, we have the 7 articles, and then we have the 27 amendments. And then the next slide, please. So here's some great websites. You may want to bookmark these. These will help you sort of, and you know, you may actually want to do this. I'm trying to think in a bookmark in a way that they, you know, you may not be using them all the time, but it might, the need to use one of these websites may come up somewhere down the line for some random paper. So you might want to have these saved somewhere that you can easily access. We've got the federal Constitution, the National Archives, and then in terms of states. So generally, this is the format. Oh, cool. So Angie used a state search one for a case brief at work. Yes. And this, so obviously you want to make sure that you have the .gov type of website that looks like it's the legitimate website, but state name, Constitution, and then you're going to be able to pull it up very quickly and easily. Then also you can find the Constitution in Westlaw, which is found in our library, and then there's annotations as well. Next slide, please. So statutes, these are also known as acts. They are laws passed by a legislature, a legislative body. It is a body, they are a body of formal law written by a legislature. So these are sort of the laws that we follow. They are used to know what the law is specifically at that time or in the past. You can search the law, or you can search statutes by section number or names. It's so nice to have these online. I started law school when we still had our physical law libraries and you had to like page through the books, and it was really no fun. It wasn't fun. And now it's so easy. You can find things so quickly and then print it out. Yes, exactly, Heather. And it's just so nice to know that, you know, you literally can get to the section that you want in the click of a button. There's always like, a table of contents. So maybe you don't even know the section that you're looking for. Maybe you don't, you know, you kind of have a general idea. You can just sort of look through the list, browse the list. There's, of course, federal statutes and state statutes. Next slide, please. So here is a little primer on the legislative process for federal statutes. So I can't ever think about this without thinking about Schoolhouse Rock and the little I'm just a bill. Yes, and Angie, I think I've played that in one of our previous classes. You know, that little snippet was very educational. So it's probably, if you grew up a lot around that time, which some of you may not have, but that is sort of branded on our brains now. So all of this, you know, additional information is just, you know, you already sort of know this, but it's always good to review the process. So legislation's proposed as a bill. It's introduced to the House of Representatives or Senate. Also, now that we have so much, like the 24-hour news cycle, there's so much now that's televised, cameras everywhere. We can actually see these processes happen. So it's kind of neat now. So it's part of our, you know, daily life. Sometimes if you turn the news on, you'll sometimes see a vote. and sometimes even hear about the process. So it's, you know, we're all sort of more informed about it, and it's, you know, it's a good thing. So then it's introduced, then it's referred to committee, then it's voted on by the chamber in which it was introduced, then it's sent to the other chamber. At that point, it may be amended or voted on. If amended, it's then sent back to the original chamber for a new vote. Both chambers must pass the exact bill. Next slide, please. Here is a little primer on where to find statutes. So again, these are some sites you may want to bookmark so that you can easily find them. Oh, we also have Hein Online in the PG library mentioned at the very bottom. And I mean, just another great resource in our library. And believe it or not, when you do all these different kinds of searches, they actually do pull up different articles. So definitely, if you haven't tried it before, maybe even before you have a paper due, you may want to just try it and see what you come up with and see the different kinds of sources. Just so the next time you have a paper, you know, you can, you know, you're ready, you know where to go. Next slide, please. And here is just a little, so we kind of talked about this before that, you know, here is a state statute. This is Indiana. You can actually, so all of these, if we were on the actual web page, these are all hyperlinked. So you can look and see, where do I want to go? What do I want to read? And you can go click on the hyperlink and it takes you right to the page. And you know, you've got it all before you. And then, you know, really easy to find. You can advance. Okay. I was talking a little fast, so I'm trying to slow down, but still keep an eye on my time. So case law, legal rules developed through court opinions. And we have the little diagram of loving, which we're going to talk about more later. These are what is a court opinion? This is the court's written statement explaining its decision in a case, and it's often written by an appellate court. The opinions lay out the court's interpretations of the constitutional, statutory, and regulatory law. So the court essentially looks at the law, they look at the statute, and then they interpret it. It's their opinion. This is and their opinion carries weight. So they're interpreting the law. And then Loving versus Virginia is an example of case law that lays out the fundamental right to marriage. Next slide, please. Case law comes from court opinions, but not all decisions or opinions at all levels are going to be considered case law. So we've got an example here. So Florida is selected as the state, and we're just sort of using Florida as an example to look at their court structure as compared to the United States federal court structure. As you can see, federal court is a little bit more complicated. There are certain things that federal court has jurisdiction over that state courts do not. And like tax court, for example, Court of Veterans Appeals. And then here, if you look at the Florida diagram, it sort of shows the structure between, we've got the trial courts at the bottom and the appellate courts at the top. There's different levels. In some states, the highest court of the state is not called the Supreme Court. It is called the Court of Appeals. But in Florida, as you can see, the highest court is the Supreme Court. Right under it is the District Court of Appeals. Next slide, please. So where do we find case law? We usually find it online on Westlaw, but if you look at that little picture, that shows you the actual books that you know, some of us who were around when we had the physical law libraries, we use these books. So a law reporter is a published volume of judicial decisions by a particular court. These might either be official, meaning they're published by the government, or unofficial. These would be published by a private publisher. And the opinions of the U.S. Supreme Court are published officially in a set of case books called the United States Reports. So the U.S. reports, those have the Supreme Court opinions. Next slide, please. And then here again are great websites to keep so that you can do searches. You know, you may want to fool around with these sites too, because, you know, someday in case you don't have access to Westlaw, you may still want to do legal research. And then you'll have these sites available to you as well. So it's always good to have. And you can switch to the next one. Administrative rules and regulations. So Congress gives, if anyone has taken administrative law, you'll learn all about these. Congress gives powers to agencies. So what is an agency? It may have department, agency, board in their name, maybe have like commission. If it's a government entity that has something like that in its name, it's an agency. So they get their powers from an enabling statute that is enacted by Congress. So Congress sort of creates the agency, gives them their powers, and then the agencies do have a little bit of autonomy and discretion. So this is the use of the power to delegate. This is given in the Constitution. And these agencies have the power to create law. This is primary authority, and agency laws are called rules or regulations. They're initially published in the Federal Register, and then eventually they're published in the Code of Federal Regulations. This is a CFR. Next slide, please. This is the CFR it comes out annually. It's the codification of the general and permanent rules published in the Federal Register by the departments and agencies of the federal government. There could be many. The CFR is available on Westlaw. There's updates. They're updated by sections. States also may have comparable publications for state administrative regulations, because remember, we were talking about the federal regulations. There's also state agencies with regulations as well. So here are some websites on where to find these resources. Next slide, please. Okay, and then we have legal. Okay, so books and treatises, we kind of talked about these already. There's a variety of them. Just as an example, the Nutshell series, we use these a lot in law schools, and horn books. We use horn books as well. These are more of like what I consider the Cliff Notes. They're very, very helpful, and they really help you understand the law. Next slide, please. And then we have legal encyclopedias, and these are pretty much self-explanatory, sort of like our old Encyclopedia Britannica, except for it's all about the law. These are also very helpful. And then we've got these two major encyclopedias that cover American law. These are listed there. Next slide, please. Then we have the American Law Reports. These are great. These publish and analyze recent significant cases, and then they're annotated. So if you need to have an understanding of a case, you can look in the ALR and sort of understand, like if there's an issue or something that the court said, you can look in the ALR and this will help guide you. They're collected by topic, and there's two types. Next slide, please. And then we've got law reviews or journals. So these are found in law schools. If you want to go to law school someday, you may actually be a member of a law review or a law journal. And you would be, either publishing them, you may be writing articles, you may be editing them, you may be doing all the fun citation work on them. So here are the common parts. We've got articles, comments, and notes, case comments, and book reviews. So they're very lengthy, they're detailed, and can sometimes be cited in court, especially, if it's from a more prestigious law school, but it depends. And then we've got these miscellaneous secondary authorities. So other types of secondary authorities that again help you interpret the primary sources. So attorney general opinions, words and phrases, legal dictionaries. You all probably are familiar with Black's Law Dictionary. Legal directories are interesting as well. Martindale-Hubbell. Form books, they can be very helpful. If you want to draft a petition, sometimes the form book is there and has a form that you want to adapt. Uniform laws, loose leaf services, and jury instructions. Next slide, please. A long time ago, when I was in college, I worked at a law firm, and I worked in their law library. And of course, it was a law firm law library, and I had to by hand update all these things all these with supplements because they were in print. So here are some where to find the secondary sources. The law reviews are often published on the school website, professional organizations, and then of course our library. Next slide, please. And then I will let Heather begin her section so that in the interest of time, thank you, everyone.
Thank you, Cristina. That was a fantastic overview of our primary and secondary sources. We'll go back to, oh goodness, let me switch sharing to a different slide deck that doesn't automatically advance. So we're going to continue talking about case law and discuss how, oh, fantastic, how we are going to create a case brief. So courts, acting in their appellate capacity, issue opinions that interpret and apply the law. These are what we're referring to our cases, those cases that make case law. Uh-oh, this one is still doing it as well. So, oh, goodness, I'm so sorry. Let me see if I can get this to pause and come out of its, there we go. So you can still see it now? Is that correct? Okay, perfect. So FERAC is the format that we're going to use to create our case brief. And it essentially is going to break down a case into its component parts: facts, issue, rule, analysis, and conclusion. Why do we want to do this? Well, when you're doing legal research and you're bringing together all those primary sources, you'll have statutes, maybe some rules and regulations, and you'll have these cases that interpret them. Sometimes you'll have 1 or 2 or 5 or 10 cases, depending on the type of issue that you're researching. And a case brief will allow you a short summary of what happened in that case. So when you're doing your research and bringing all your research together, it's a nice, concise way to organize. We'll go to our next slide. So it is essential that we understand the case. And in order to understand the case, that sometimes means we have to spend a little bit more time with it. Courts are notoriously confusing writers, meaning that they include all kinds of language and verbiage, and some courts are very express. Some courts just keep going and going. You might have a case that you're reading that is a page or 2 pages long, and it might be 50 pages or more. So expect to read the case more than 1 time. As a matter of fact, I'm going to encourage you to read it at least 3 times. The more familiar you become with the language, the easier it will be to read them. So we're going to use Loving v. Virginia as our example tonight. Professor Nolan gave it as an example of case law, and it is as I mentioned here, a constitutional case that lays out the fundamental right to marry. So we'll start by reading the case, a first read, a second read, and on the third read, we'll put together the case brief. You can access the Loving v. Virginia case by any of the methods that were just discussed, such as going through Westlaw, entering the case name or the citation. You can even put the case name into your favorite internet search engine, and it will likely return you to, even if it returns you to the Wikipedia site, it will reference this case. It will give you the case citation. Absolutely. And you can take a read of the case and then see how it all breaks down. So let's start with the first read. On the first read, you have to identify the parties in the case. Who is this case about? What's it talking about? Lisa, absolutely. It's why I reiterate it here as well. 3 reads. Identify the court deciding the case. Is this a Supreme Court case? Is this an appellate level case, federal case, state case? Then read the whole thing. See what happened. Get a general idea of what the case is about. So the Loving v. Virginia case, the parties are Mr. and Mrs. Loving, and the respondent in this case is the state of Virginia. The court that decided the case is the United States Supreme Court. So we know it is an important case. The case was decided in 1967. It's always important to note the year, ideas, attitudes, and case law and statutes change across time. The next point is to read the opinion. Pay attention to what happened in the case. The Loving v. Virginia case started out as a criminal conviction. It was against the law for Mr. and Mrs. Loving to be married in the state of Virginia because they were of different races. It was a crime. Oh, I'd love to color code. All right. So now that we've made it through our first read, usually you can take a breather and come back to it. Do your second read. This is when we begin to understand what happened in the case. Read through the whole thing again. You know who the parties are and the court deciding it. As you're reading through, pay attention to how the case has moved through the court system. What is it that the court was asked to explore? Did the court make a clear determination at the end? Once you've gone through your second read, and you think you have a better understanding of the case, it's time to compose your FERAC brief. FERAC is a nice condensed method for briefing a case. Back in the days when we had to use only books and there was no internet and no online researching, and I will show you the format in just a moment, we created case briefs with 8 and 10 and 12 component parts. This is the modern cutting edge way to break down a case into practical using component parts. Facts, issue, rule, analysis, conclusion. Each will be labeled in your writing to make it nice and easy to follow. Now, you may have already heard about IRAC, issue, rule, analysis, conclusion. And we use an IRAC format in just about all aspects of legal writing. So for our case brief, we're adding in those facts at the beginning. Most of us, when we're working with case law, think about a case in terms of facts. The holding, Lisa, we're going to relate the two in just a minute. Now, the issue is going to be more like your question presented. All right, so let's take a look at our Loving case. We're going to start with the facts. The facts in this case are that Mr. Richard Loving was a white male and Mrs. Mildred Jeter, eventually Loving, was a Black female. Both were residents of Virginia. That is a picture of them right there. They were married in Washington, D.C., but they lived in Virginia. Shortly after their marriage, both Mr. and Mrs. Loving were charged and pled guilty to a violation of the interracial marriage prohibition law of Virginia. Their sentence was suspended if they agreed to leave Virginia and not come back together. They relocated to Washington, D.C. and sought to have their convictions vacated and instituted a class action on the grounds of the 14th Amendment. Now, when you read the case, There are a lot more facts included, more about the Lovings, more about the case as it moved through, arguments that were made in Virginia. You only need in your facts section the facts that are necessary to lay out the analysis in a very concise fact section. The plaintiffs pled guilty to a violation of a state statute prohibiting interracial marriage. Plaintiffs sought to have their convictions vacated as unconstitutional under the 14th Amendment. Exactly, Lisa. The next step is determining the legal issue. Questions about facts. It is very easy to include an entire story when you begin to draft the facts. That's okay. On your first round of drafting, include what you think you need, and you can always go back and eliminate that which is unnecessary to tell the story, to have the rest of the issue and the rule make sense. Next, we're going to look to the legal issue. The issue is the legal question that the court is being asked in the case. Sometimes we refer to it as the question presented, and sometimes the court will straight up tell you the legal question in this case is. And when the court does that, you think, yes, excellent. That's what you highlight, that's what you showcase. They're telling you exactly what legal question they plan to answer in that opinion. The issue should focus on law and not fact. The facts are determined, but the law and how the law is going to be applied is the question that we're asking the court. Oftentimes, you'll want to phrase the issue as a question. The whether, W-H-E-T-H-E-R, question whether is a great way to start your issue. It sets you up for comparison and creates that question. So that's why you will often see whether at the start of an issue statement. Now, not every single case that moves through the courts and leads to a court opinion is going to have just one issue at bay. Sometimes the court will be dealing with multiple issues, in which case you will list out issue 1, issue 2. And you can follow that all the way through the rest of your analysis. So for the Loving v. Virginia case, here are 3 different ways we could state the issue. Whether the Virginia law restricting marriage based on race violates the 14th Amendment of the Constitution. Whether the due process and equal protection clauses of the 14th Amendment can be used to invalidate the Virginia laws restricting marriage based on race. Or whether the statutory scheme adopted by the state of Virginia to prevent marriages between persons solely on the basis of racial classifications violates the equal protection and due process clauses of the 14th Amendment. Which issue do you like the best? The key with a case brief, since it is part of your research process, is making it understandable and readable to you. No preference? More straightforward, more complex? More straightforward, I like it straight to the point as well. So once you have that issue, the next section is the rule. And I think here we answer your question. This is also sometimes called a holding. I'll show you another structure that's used for a case brief, a more traditional format, and it will have it as well. All right. So the rule answers that question that was just posed in our issue. The rule often has a yes or no, and then explains the answer to the issue. If there is more than one issue presented in the case, you might imagine that there will be more than one rule provided. So you'll want to list them all out. Here are issue and rule pairings for the loving case. With a more complex issue, you may choose to have a more complex rule. So rather than Lisa, it maybe, then that would be a yes with a exception or limitation. So absolutely, that would be the explanation part. For sure. And, you know, the courts will interpret and explain. Some courts will be very straightforward and give you a yes, like we've laid out here. This particular case, the opinion is written very well. It makes it a little bit easier to identify each of these sections. That's why we picked this case. And some courts will be more straightforward, more clear than other courts. After all of our judges and justices are people, and they all have their own individual writing style and habits. So the next section is the analysis. This is the what happened and how did it happen. This is where you address the why of the case, sometimes referred to as the rationale or the reasoning of the court. Absolutely. So this section of your case brief is often going to be the most detailed portion of the writing. This is where you explain how the court got to a question under the law to an answer. That in-between part where the court lays a foundation in the law, maybe a statute or a regulation, and likely brings in other cases and interpretations to explain how the rule and the determination in the case was achieved. Now, sometimes when you're reading a case, the court, when it is articulating its opinion, knows. And the court writing the opinion thinks this case is going to lay a path for the jurists when they are bringing these kinds of cases forward in the future. And thus the judge will articulate maybe some clear parameters or some rules or process. When you're reading a case like the United States Supreme Court, it is going to include a lot of additional law. This Loving v. Virginia case looked at constitutional implications. So you know the US Constitution is referenced, as well as how the law has been interpreted in other jurisdictions. This is the challenging part, right? Because we have to be able to understand the court's rationale, how the court got, and then articulate it. So in an IRAC section, the analysis would begin with a little factual paragraph and then move into the law. In the, in the FERAC format, we put those facts at the start, get our story. Absolutely. And that is the challenge, remembering that our courts are writers, and some are more honed than others. So here's how we break down the analysis in a very concise format for the Loving v. Virginia case. You want to include enough information to explain what the court relied on without having to regurgitate everything that they've already put into the opinion. You want a case brief to be concise. Back when we used to have to write them out, it was 1 page or 2 page maximum. Even for a United States Supreme Court case that is chocked full of law and analysis. So here, analysis. The court rejected the state's claim of equal application and looked at equal protection under the 14th Amendment, evoking the highest level of scrutiny, showing a permissible state purpose. The statute did not meet the level and sought to specifically create a racial distinction. The Virginia statute specifically limited the fundamental right to marriage in violation of the Due Process Amendment. Oh, absolutely. It's like the dicta is that extra stuff that the court puts in that sometimes will be called out in subsequent cases. And multiple reads help us to dig through some of the extra that gets put in there by some of our justices who do like to be authors of opinions. So the conclusion in this case, concise, succinct. We even have a little picture here of the court making this decision. The plaintiff's convictions were reversed on the grounds that the Virginia law violated the equal protection and due process clauses of the 14th Amendment. The court said in the opinion, marriage is one of the basic civil rights of man, fundamental to our very existence and survival. So I mentioned no, Lisa, no, 1 sentence is acceptable. The most concise case brief may, in a FERAC format, may just be a sentence or 2 for each section. I myself am never able to keep it that concise. I limit myself to a page or 2. Absolutely, Mary Ellen, but the problem I have with the shorter the better is that sometimes we make it so short that when we go back to look at it, it doesn't have the beneficial aspect of looking at it and understanding what happened in the case. Instead, we have to go look up and see exactly what we meant or are missing some detail. So I err on the side of a little longer. You can always make it more concise. Lisa, yes, it's the one that comes right after that rationale. The conclusion is oftentimes much more straightforward, and sometimes the court will just spell it out for you. It's the rationale, that analysis section. When you have a great court that lays it out, then writing a brief is a pleasure. So I mentioned before that there are various forms of case briefs. A traditional form had more information. Notice that dicta term. Procedural history, facts, issue, holding, analysis, application, disposition, dicta. One of my professors added 3 more sections to it. I also like to include, even when I do a FERAC case brief, after the conclusion, I include a summary of any dissent or concurring opinion. While it isn't part of that FERAC method, the FERAC is going to be that analysis of that majority opinion, the one that is going to be the case law. But it's always important to know what either a justice who doesn't agree with, who agrees with the outcome, but not the process in a concurring opinion, or justices who don't agree and come to a different conclusion and write a dissent. It helps you to better understand the legal issue that is being brought forth. So which format for what? It really, this is a legal research. This is a legal research that you're doing in your office or for school. So it's really up to you. FERAC is the modern way. This is the way you're going to see it most often. And how we do it here at Purdue Global. Right. That first case you brief is challenging and kind of stressful. But after, say, the 20th case, and it seems like that would be a lot, but thinking about how important our primary sources of law are, and when you begin doing research, you are going to read a lot of cases and thus be able to construct a lot of case briefs. The more you practice, the easier it becomes. Yes, absolutely. It can even become somewhat comfortable. I dare say fun, but I might be pushing it. Right. So I also wanted to make the contrast. There are 2 different kinds of briefs. Tonight, we've been talking about a case brief. And these are the research tools that we use to summarize a court opinion. Court briefs are the ones you oftentimes hear an appellate brief filed. That is a court brief. Court briefs are not brief at all. They are actually quite lengthy. They're written in a formal style. They have a table of contents, a table of authorities, and they include a legal argument. These are filed with the court in support of pending litigation. Very, very different than our case brief. Court briefs don't use that FERAC format. They have a very strict, oftentimes defined by the rules and regulations of that jurisdiction format. All right. We also included a reference page. Professor Nolan went through a plethora of resources at our start, and there are all kinds of links. We will send out, or at least I will, make sure we send out the PowerPoint to our list of participants. Hey, Shiloh, welcome. And we will make sure that we have the recording and the PowerPoint available. And so now we're right here at the end of our presentations. Feel free to, oh, thanks, Cristina. Ask questions. Oh, Mary Ellen, yay. Cristina, you're awesome. Thank you. All right, Melanie. Criminal law is a fun one. Excellent. Mine too. Mine too, Angie. All right.
Yeah, and I was just going to chime in. We do have, looking at my clock, we do have a few minutes for questions. So, Angie's you're too kind, Angie. If anyone has any questions, I think it's been great to see so many questions and participation in the chat. It's really made it enjoyable, and I think kind of push Professor Valdez and I to sort of really think about the issues sort of from your perspective, and someone who's learning how to do these skills and use these resources. Oh, Lisa, exciting. I look forward to seeing you.
Right. Any final questions? Oh, good. Yes. Legal Ethics has a book.
That's right. That's right.
One of the few. One of the few.
Yeah,
Still.
it really is. Oh, that's exciting. Yes, Angie, for sure. Lisa,
right.
so I hope you enjoy your short break. You're almost at your break time for we're almost done with unit 10. So good. Enjoy, get a little bit rested up.
Yeah. We are both on A track. That's right, Mary Ellen. So although we won't see you, we do wish you the best. You'll have a good time in that criminal law class. All right.
Thank you, everyone. We really appreciate you taking an hour out of your evening. I know on the one night that most people don't have class, so we really appreciate you being here and hope that you found this to be a good use of your time. Yes, Lisa, I echo that too. Good luck to everybody in their masters, their further education, law school for Mary Ellen and maybe others. So yes, excellent, Stacy. Business law is a great class.
It is a fun one. Well, thank you, Lisa. It's our pleasure.
Awesome, Mary Ellen. Thank you, Angie.
Oh, good.
Lisa, that's so good to hear. Oh, yay.
Oh, good. Well, good luck. That's
exciting,
awesome.
Lisa.
All right. Well, thank you all for coming this evening. Best of luck to you all and have a great evening.